Yes, thank you, Joseph, and it's a pleasure to be here at this conference in honor of Adrienne. Now, yesterday, several people boasted about their proximity to Adrienne, former students, colleagues, etc. For me, it's a bit more difficult because I belong to another discipline altogether. So I think I'm the first non-political scientist who is speaking at this conference. But I have something else. I have another boast, namely the fact that my picture is together with Adrienne's on the same page in this annual report of UDO. So we are next to each other, which is really nice. And the reason why we're next to each other is that for the past few years, we have together co-directed one of the sections, one of the observatories of UDO, namely the one on institutional change and reforms, bringing together the disciplines of political science and law in looking at those issues. So it's in that context that I'm really also happy to be here and to continue this dialogue between the disciplines and between the two of us on issues of EU institutions. And therefore, the theme I've chosen is a typically legal theme. It's looking at institutions by bringing in a legal dimension, namely the possible role of fundamental rights, and with a question mark. So can we say that if we look at especially the last 5 years since the entry into force of the Lisbon Treaty, can we say that the institutional balance in the EU has been transformed by means of fundamental rights? Is this the number of minutes?
Yes, this is your time.
So my starting point is one of the insights of Adrienne Héritier, namely the fact that the institutional change in the EU doesn't only happen by means of the big changes through treaty revisions, but also by means of what she has called in her work interstitial rules. That is to say, rules that are formulated by the institutions themselves in between treaty revisions, both formal and informal rules. In her vocabulary, formal rules, of course, for us are legal rules and informal rules that are developed by the institutions in between treaty revision. And because they are developed and practiced, in reality, they cannot easily be turned back later on by the member states when they revise the treaties again. So it's an important source of institutional change. And in this continuous reshaping of the institutional balance, the institutions, the political institutions, occasionally seek rulings of the Court of Justice to support their preferred outcome. And there again, Adrienne has done quite some work together with some co-authors on seeing in which circumstances and for which purpose EU institutions seek rulings of the Court of Justice to support their own position. And for example, that explains the case law on the choice of the decision-making procedure, okay, the choice of legal basis for doing something. That is important for the institutions because the decision-making procedure may be different. It may be qualified majority in the Council or unanimity, so they seek support from the Court of Justice for the option which they prefer. Same thing for the extent of EU competence. Is there an exclusive EU competence on a certain matter, or is it shared with the member states? That has immediate institutional consequences, and also there, the Parliament, the Commission, and the Council like to go to the court to get its support for their interpretation. What I want to look at is something else, namely it's the role of fundamental rights. So not rules on competence, not rules on decision-making, but fundamental rights as a source of what I would call institutional turmoil. That is to say, turmoil, nuisance, if you want, for the institutional functioning that comes from outside the institutions. And there are 4 reasons, which I put here on this slide, why fundamental rights may be expected to be a source of institutional disturbance or turmoil. The first reason is that fundamental rights act as trump cards. Because they're fundamental in the legal system, therefore they prevail over normal lawmaking, normal laws, they prevail over normal decisions of the institutions. So there are trump cards that can be used. Secondly, their formulation is often open-ended of fundamental rights. If one looks at the Charter of Rights of the EU, one sees that it's very general formulation and which leaves room for interpretation. That interpretation, in turn, is entrusted to independent actors, to non-political actors, essentially the courts, but also others, who are mobilized not only by the EU institutions, but also by others. Okay? Individuals can bring claims about rights and disturb in this way the institutional functioning. And finally, the last element to be noted is that the role of fundamental rights was upgraded by the Lisbon Treaty in the sense that the EU Charter of Rights that existed since 2000 but had remained a sort of unidentified legal object whose status was not clear, not binding anyway. Through the Lisbon Treaty, it has become part of primary EU law and it is binding on the EU institutions. So if we take all these elements together, one could expect, possibly, fundamental rights to act as a source of institutional change. Now, when I look at what has happened in the last 5 years since Lisbon, I would see 4 ways in which there has indeed been some interstitial disturbance, if I may say so, by means of fundamental rights. And I will detail those 4 sources of disturbance in the next slides, but I've put them here just by way of general presentation. One, of course, is judicial interference with political outcomes. The Court of Justice applies fundamental rights and can, by doing so, disturb outcomes which the political institutions have reached between themselves. That's the classical way in which constitutional rights also function at the national level. It gives power, it empowers constitutional courts. The second way is that among the political institutions, one of them, the European Parliament, has actively used fundamental rights arguments to interfere with the normal functioning of the institutional relations, to support its own position, in a way, you could say. Thirdly, what we have seen is that increasingly we have other institutional actors beyond the Court of Justice, independent bodies whose program, whose objective includes the protection of fundamental rights and who have tried to enter into the institutional debate in a number of ways. And finally, the 4th source of disturbance is external interference from outside the EU system by international actors, international courts and monitoring bodies who have had an impact, or tried to have an impact at least, on the EU's institutional functioning. Okay, so let me now take each of those 4 elements in turn very briefly. The first one is judicial interference with political outcomes. Traditionally, the Court of Justice has been very cautious in using fundamental rights when reviewing, when examining EU legislation. It had been less cautious in looking at member state actions, but when looking at the legality of EU legislation, the Court of Justice had not made an active use of the general principles of law, which was the source of fundamental rights. What we seem to see, but here I'm a bit cautious, but we seem to see since Lisbon, since the time the EU Charter became a written part of the EU Constitution, we seem to see a more active role of the Court of Justice also in respect of the EU legislator. One example I put here, and it's perhaps the most spectacular so far, is that in a judgment of April, I think, of this year, the Court of Justice struck down an entire piece of legislation. So the Data Retention Directive, which had been adopted in 2006, so which had been in force for 8 years, which had been transposed into national law in every country except Germany. So you have a whole set of not just European but also national legislation, which is now being struck down by the Court of Justice. What is the Data Retention Directive? It's a directive which imposes on service providers a duty to keep the metadata of all the users. So whenever we send emails or whenever we send messages, SMS messages or whatever, the metadata have to be kept by our service providers. That is to say, who sent the message, who received the message, when and where, not the content, okay? Why is there this obligation? In order to facilitate crime fighting, in order to facilitate investigation of crimes by being able then to look back at how suspected criminals have communicated with whom in the past period. So this system had been put in place in 2006, been implemented everywhere, and now the Court of Justice said, well, actually, the very idea of data retention, of keeping everybody's data, metadata, is already an unacceptable violation of the right to privacy. And therefore, the whole directive goes down the drain, with reverberations also on the difficult ongoing legislative negotiations at the EU level on new data protection legislation. The other example is a more specific one. It's about a piece of legislation, the 2004 Directive on Equal Treatment of Men and Women in Access to Goods and Services. An essential part of the deal that was struck by the institutions when adopting the directive is that there would be an exception for insurance contracts. That is to say that insurance contracts could continue to distinguish between men and women based on statistical evidence. That is to say, for example, if there is clear evidence that women have fewer car accidents than men, which is the case, then insurance companies are allowed to charge different prices from men or women. So that exception, if you want, to the principle of equal treatment was written in the directive, and it was one of the central elements of the negotiations, taking into account that the directive had to be adopted by unanimity. Okay, so all the member states had to agree. A number of years later, 5 or 6 years later, the Court of Justice says this exception is illegitimate. It's a violation of the principle of equality. It's a discriminatory provision. You're not allowed the legislator was not allowed to give this derogation to insurance companies. So here you see the Court of Justice overruling directly a legislative compromise which was hard fought and which was known to be hard fought. So direct interference, I would say, with institutional balance. In other words, you could say if the member states had known beforehand that the Court of Justice would have interpreted things in this way, they would never have adopted the directive in the first place. The second element is rights activism by the European Parliament, which is, of course, the element which fits best, I would say, in Adrienne's theoretical framework, because what we see here is that one of the institutions uses a legal argument in order to modify the institutional balance, to produce some interstitial change. I've put, again, 2 examples of this here. One example is that the European Parliament decided last year to investigate the role of the Troika, Commission, Central Bank, and IMF in the Euro area program countries, so in the bailout countries. So it organized hearings and it asked representatives of the European Commission and of the European Central Bank to explain on whether and to what extent they had looked at the fundamental rights consequences of the conditionality imposed on Greece and Portugal and Ireland and so on. More specifically, on the extent to which those austerity measures imposed by the Troika would be compatible with the social rights, fundamental social rights of people. Right to health, right to education, right to fair remuneration, and so on. So the Parliament uses fundamental rights in order to enter the game of the Euro area rescue mechanisms from which it had been excluded to a large extent. Because all this happened without much parliamentary participation, so the Parliament came back into the game, among other things, by using the fundamental rights argument. A clearer example is the fact that the Parliament has used its new powers since Lisbon to give its consent to international agreements of the EU by striking down a number of high-profile international agreements which had been negotiated and concluded by the Commission and the Council. So the Parliament enters afterwards, once the agreement has been concluded, and says, we don't like it. We're not going to approve it. So this happened with agreements with the United States on the transfer of personal data, and also, perhaps even more prominently, with the ACTA, the Anti-Counterfeiting Trade Agreement, a major multilateral agreement on the enforcement of intellectual property. After painful negotiations, the text had been approved by the negotiators, and then the European Parliament says, we don't like it. We think it doesn't give sufficient guarantees to private life and communications, to fundamental rights, and therefore we are not going to give our consent. So that was the end of the EU's participation in ACTA. Third element is the role of independent bodies, whose competence includes, directly or indirectly, the protection of fundamental rights. And it's most obviously the case with the Fundamental Rights Agency in Vienna. When this agency was set up, the institutions, and especially the member states, were careful to try and avoid this agency from interfering with the legislative process. So it can only comment on proposals for legislation on demand. That is to say, if one of the political institutions, Commission, Council of Parliament, asks the agency for advice on whether a particular proposal is in accordance with fundamental rights, then the agency can come in. And it has done so a few times. But it cannot do so on its own initiative. So this is clearly a way in which the institutions have tried to limit the interference by this outside actor into the decision-making process. On the other hand, the European Data Protection Supervisor does have the power to to give opinions on his own initiative. And he has done so quite often in defense of privacy rights in relation to data protection. For example, the Data Retention Directive, which I mentioned before, had, before the court decided, had been criticized very strongly and very elaborately by the Data Protection Supervisor. And the analysis which this body had proposed was certainly influential in the way the Court of Justice finally decided the case. And then we have the European Ombudsman. As we know, its function is to look at maladministration in the EU system. But it has defined, the Ombudsman has defined maladministration as including also respect for fundamental rights. And so fundamental rights in the latest annual report of the Ombudsman is listed as one of the key topics, one of the key concerns of the Ombudsman, and one of the actions it took last year, the current Ombudsman took last year, is to put pressure on Frontex, so the agency for the control of external borders, to create a complaints mechanism allowing individuals, essentially migrants coming to the borders, to complain about fundamental rights violations. A mechanism which did not exist, and I think doesn't exist yet, but the Ombudsman has put very strong pressure here on Frontex. And finally, the fourth and last element of institutional disturbance from outside this time is from international bodies. The example I want to propose here, the main one, is the fact that the European Court of Human Rights in Strasbourg, although generally speaking is quite cautious when it deals with the EU, it tries to, to stay clear from interfering too much with the EU system, it still does in some cases. And the most obvious example, I would say, is the way in which the Court of Human Rights has basically destroyed the functioning of the Dublin system for allocation of asylum seekers. It's an EU system, it's an EU regulation called Dublin because it was originally an international treaty signed in Dublin, but it's basically an EU regulation which, as you know, says that only one EU country is responsible for examining asylum seeker, and in principle it should be the first country in which the asylum seeker enters the EU territory. Meaning that if those asylum seekers later on move to other countries, the other country can send them back to the first country. So that's the Dublin system. Now, in a number of cases, the Court of Human Rights had already said that that asylum seekers should never be sent back to Greece under current circumstances because the conditions of reception of asylum seekers in Greece constitute inhuman and degrading treatment in violation of the European Convention. And now more recently, in a judgment of the 4th of November, the court has added that Switzerland was not allowed to send a family of Afghan asylum seekers to Italy because there were no guarantees for decent conditions of reception of this family in the Italian asylum reception system. So it spreads from Greece to Italy, and the important thing is that the court says you have to look at each individual situation, whether this particular asylum seeker or his or her family can actually be given decent treatment, meaning that the whole mechanism of Dublin, which is based on automatic sending back, on automatic functioning, is completely disturbed by this interference. I could also mention the European Social Rights Committee, which has criticized the way in which the bailout conditionality has dealt with fundamental social rights, very strong criticism of the EU's activity. And of course, in the future, this is going to increase because the European Union very soon will become a member state of the, a party to the European Convention of Human Rights, which will make the Strasbourg Court now really a final authority on fundamental rights compliance by the EU institutions. So there you really will have an outside actor which will be able to interfere with the EU institutional process. So my conclusion, there's two conclusions. One is tentative. I'm asking myself the question whether these trends which I mentioned to you are sufficiently strong, sufficiently real to conclude that we do have a new fundamental rights culture that is permeating the EU's institutional relations. So do we really have a transformation of the institutional balance by means of fundamental rights? I think the question is still open. I've given some elements for a positive answer, but I'm not entirely sure myself. But what I can say more generally, and then now relating again more directly to Adrienne's ideas about institutional change, what I would argue is that interstitial change, so changes in the EU's institutional balance in between treaty revision, may be caused not only by the action of the EU institutions themselves, but also caused by non-political EU actors and even outside actors from outside the system. And fundamental rights is one of the main vehicles which has been used, which can be used to do so. Thank you very much.